Okay, this is the Committee of the Whole, and tonight we'll have several considerations. I'm not sure what happened to number 3, but we'll find out what that is when we get there, I guess. The first consideration is discussion of the city's home rule sales tax, and I think this is very timely and pertinent. I'm very pleased that we will have this discussion related to where we are fiscally, how it relates to the home rule sales tax, and some things that we've done in the past to be, I think, hopefully very proactive, as I think, and move forward with the city. So,
we have 2 parts to this discussion. I'll lead off with the first part, and then we'll turn it over to Rudy for the second part. The first part, 2 parts. The first part is in reference to some information that's been circulating throughout the community, whether in general or as part of some campaign discussions, that we thought it important to get some facts and figures out there so that people can use the information to speak with facts and figures behind them as they speak to the issue of home rule and whether or not the city would lose its ability to continue to levy and collect home rule taxes should it lose its home rule status. So we'll have a discussion about that. The second part, Rudy will conduct, and is in response to the City Council's directive back on August 25th, asking that at this meeting, March 9th, that you bring up for discussion the possible rescission of the home rule sales tax increase that we did effective last July 1st. Okay, so the first part. As I mentioned, there's been some discussion in the community regarding the advantages and disadvantages of home rule, and despite the fact that this topic did not successfully make its way on the ballot, it's always important to continue and provide information so that the discussion about the benefits or disadvantages of home rule can be discussed at large within the community. One of the points being raised and a question that has been asked is, as I started at the outset, what happens to a municipality that presently levies and collects home rule sales taxes? What if that municipality loses its home rule status? And the general belief is that the community would in fact lose its ability to continue to collect those home rule taxes if it lost its home rule status. Now, there's some confusion on this point in that there's various conflicting pieces of information that I could see why would perhaps cause some question within the community. The first is an opinion by the Illinois Municipal League. They published a Q&A, a legal Q&A on home rule, and in March of 2007, their particular brief on this topic talks about a variety of issues. One of them is exactly this question: what happens to the city's ability to continue to collect taxes, home rule taxes, should it lose its home rule status? And they concluded that if a municipality elects to go from home rule to non-home rule, it does not affect the validity of the actions taken while it was home rule. So that would allow one to conclude that even if you became non-home rule, you would still be able to collect home rule taxes that were lawfully put into effect when you were home. However, there's some other opinion pieces that contradict that. The first is a Department of Revenue opinion that was issued in 1998. This was issued in response to an inquiry made by the City of Rolling Meadows, who at that time had their then upcoming April ballot a question of home rule rescission. The city posed a question to the Department of Revenue if in fact would it lose its ability to continue to collect home rule taxes that they had lawfully enacted should they lose their home rule status as a result of the upcoming April ballot. In that case, the legal division within the Illinois Department of Revenue concluded that the city's home rule taxes would be eliminated at the time that the municipality lost its home rule status, and that further the department, meaning the Department of Revenue, would no longer be obligated to collect on the municipality's behalf those home rule taxes. That opinion is also mimicked, if you will, by a 1983 Attorney General's. All this information is your background materials if you have a chance to review it. So there's some conflicting information from both the Attorney General's opinion in 1983 and the Department of Revenue's opinion in 1998 that conflict with the IML piece. Both those former pieces, the DOR and the Attorney General, say that you would not be able to collect home rule taxes after you lose your home rule status. There is one exception. The DOR references this in a Rockford case in 1983 when Rockford lost its home rule status. In that case, the courts and the appellate court ruled that the city of Rockford can in fact continue to receive home rule sales taxes after it lost its home rule status, but only if those taxes were otherwise pledged to pay down debt. In that case, I believe there was an exposition authority or something with a downtown facility wherein the city bonded for that improvement and pledged to pay those bonds with the then in effect home rule taxes. In that case, the contractual obligation supersedes the former Attorney General's opinion that in those instances, the home rule taxes can continue to be collected. Now, all these opinion pieces are now at a minimum 10 years old, if not older. This question has not been asked nor tested since. The last home rule rescission vote was, in fact, the Rockford case in 1983. Prior to that time, in the 70s, I believe the early 80s, other villages have, in fact, rescinded home rule. But it's unknown as to what circumstances they confronted when, in fact, that rescission took place as it relates to the continued collection of home rule taxes. We do have a call into the DOR to see if, in fact, there's an updated opinion to this 1998 opinion. We also have a call into the former city attorney for Rockford that Norma was a colleague with in her private practice to learn more about what they did on the days after they lost home rule. But for now, the opinion pieces that we receive and have in our hands would suggest that, in fact, the city would lose its ability to continue to collect home rule taxes if it were to lose its home rule status. What does that mean specifically for DEKalb? Presently, DEKalb collects $8.2 million in various home rule related sales taxes. The home rule sales tax, the restaurant bar, some natural gas, hotel motel as it relates to their use for general purposes as opposed to tourism. In total, $8.2 million. We also have in our general fund a $1.5 million annual debt obligation. We looked up those debt instruments when they were adopted years ago, and those debt instruments were pledged with property taxes, not sales taxes. So if we were to lose our home rule status, we would not have that exception from the 1983 case in our favor because we did not pledge those debt payments with sales tax. So in sum, given the information we have and the various opinions, it would appear that the city would have at risk its current $8.2 million in annual sales tax collections would be lost if we were to lose our home rule status. Certainly a lot of money, roughly 1/4 to 1/3 of our total revenues would be lost upon a vote to rescind home rule. Another way of equating that, it would be roughly 60 to 80 of our city's 230 employees, given that the majority of our budget is personnel-related expenses, would probably have to be terminated so that we can meet our annual goals of adopting a balanced budget. I make a point in here, what's left of the IML opinion? Remember, the IML opinion says that our ability to carry on things that were done validly when we were home rule continue after we're not home rule. I believe what's left then of that opinion, again, absent anything else we're going to learn from return phone calls, would be perhaps actions that are of a regulatory or programmatic nature by the city that occurred lawfully while home rule, but now can continue to be imposed once you become non-home rule. For example, the example I gave in here is because we're a home rule, we're able to enact greater fines for ordinance violations than would otherwise be the case if we were non-home rule. Perhaps that's one exception that the IML references, that if we became non-home rule, we can still enact and levy those greater fines because we did so at the time that we're lawfully home rule. So perhaps that's the exception IML is referencing. The next steps in our discussion on this point be to receive that information from the DOR. I don't believe they'll give us a verbal opinion. We'll have to ask for it in writing, and they'll return it in writing. And likewise, have a conversation with the former attorney in Rockford to find out more about what happened in their case. We could pose questions, and now, again, that's 25 years ago. Hopefully memories and files are still present to learn what kind of actions they took on the days after they lost home rule. We could go back to the other towns that rescinded home rule prior to that, the Lyles and the Lombards of the world, but really going back in 30-plus year history. So we're going to start